In just a moment, joining us now here in the studio to talk about it, Judge Alex Ferrer, host of the syndicated television program, Judge Alex. Great to see you.
Great to be here, Greg.
John Good was on the defense witness list. We knew about him. I found him in my notes 3 months ago, exactly what he was going to say, that he was going to be a terrific defense witness, saying that Trayvon Martin's on top, Zimmerman's on the bottom being attacked. Did prosecutors nevertheless call him, even though they know he's going to hurt their case, because they don't want to be accused of hiding something from the jury?
That's absolutely right. That's exactly why. They want to diffuse it. They want to take the wind out of the defense's sail. They don't want it to be a gotcha moment when the defense says, but look, we've got this eyewitness. And by the way, the prosecution knew about this eyewitness all along, and they didn't present him to you, which they can do in Florida. The Supreme Court has ruled that in closing arguments, if the prosecution does not call a witness and the defense has to call a witness with specific knowledge, prosecutors can tell the jury, which I disagree with, I had to call the witness, even though we don't have a burden of proof, because the prosecution was attempting to tailor the evidence they presented to you. So to avoid that, they took their lumps early.
Right, so this witness says, look, Martin's on top, he's straddling Zimmerman on bottom. It looks like there are punches being thrown. But there's one thing that prosecutors are seizing on, and that is that John Good says, well, his head wasn't being slammed to the concrete that I can see. Is there really a material difference between slamming a head and punching a head into the concrete?
Well, I mean, there is in this case, because Zimmerman is claiming he was in fear of death or great bodily harm, and,
right.
and slamming your head on concrete is a lot more dangerous than a punch to the nose, although I wouldn't like either of them. But what's significant about this testimony is that even though he didn't see it, he claims he only saw about 10 seconds of the altercation, which ran at least 40 seconds on tape of the 911 call and somewhat longer before that. So during the time he wasn't watching, certainly defense attorneys are going to argue it was then that Zimmerman got these injuries in the back of his head.
Yeah, pounding, ground, dominant position, MMA style, all of this language that the jurors heard today favors the defendant.
Yeah, and then the difficult part for the prosecution is, at this part of the trial, it's their part of the case. You should be feeling like this is a powerful conviction. They've definitely got evidence for murder here, because it usually starts shifting when the defense presents their side of the case. Right. We haven't gotten to the defense side, and it's already suffering.
John Good also said one other thing that helps the accused, and that is he believes it was Zimmerman who was crying out for help. That really undermines the narrative of prosecutors of who was attacking whom.
That's correct. And he explained why. He said, I can't be certain, but he said Trayvon's body was facing away from him, and the voice he heard yelling for help seemed to be coming from someone at a short distance facing him. It did not seem like a distant voice. And of course, logically, he felt the guy at the bottom who's getting pummeled would typically be the guy who's yelling for help.
All right, let's go back to Phil Keating. Phil, I understand the judge has made a key ruling. What is it?
Oh, not just yet, Greg. She has yet to rule. She's still giving the attorneys time to present their legal frameworks for why or why not George Zimmerman's previous criminal history should be allowed into this trial. This came up late yesterday afternoon when a witness was on the stand, and defense attorney Mark O'Mara basically said, have you ever seen George Zimmerman in your neighborhood be angry and hostile and a hothead? And she said no. And that then triggered Bernie De La Riona, the lead prosecutor, to then tell the judge he wanted to proffer the witness. The jury was excused, and he proffered the witness saying, did you ever know that George Zimmerman actually had a restraining order against him for beating up his ex-girlfriend, and that he also had an assault arrest for intervening in an altercation where he got in the face of a law enforcement officer? By the way, both of those cases were ultimately dismissed. But the judge is going to weigh it out. Of course, defense attorneys don't want that entered into the evidence at all, since it's Zimmerman's past and doesn't necessarily look good for a defendant.
Yeah, that certainly is an understatement. Doesn't look good for the defendant if that comes in. Fortunately, we have a judge sitting here, and a Florida judge to boot. Did the defense attorney mistakenly open the door, as they say in the law, for prosecutors to present past conduct beyond what happened in this case?
It certainly sounds that way. I mean, typically you can't introduce evidence of prior bad acts of the defendant. That's inadmissible unless on very, very narrow circumstances, and it's one of the most frequent grounds for reversal. However, if the defense attorney gets up there and attempts to paint a picture through a witness that he doesn't have any prior violence, that opens the door.
Yeah, prosecutors also likewise have to be very careful that they don't portray Trayvon Martin as this angelic kid who never did anything wrong if they go that far.
Same
That
thing.
allows the defense to revisit a motion to reconsider, to have gun evidence, fight evidence, marijuana use, all kinds of stuff to come in about
Absolutely.
Trayvon Martin. All right, Rachel Gentel was supposed to be the star witness, the girlfriend of Trayvon Martin. Now, tell me what you told me during commercial break about something interesting that happened here relative to her.
Well, when she testified, she talked about the fact that the first time that she was interviewed by the police, they swung by her house and they picked her up in 2 cars. In one car, it was the detectives, the state attorney who was going to interview her. In the other car was Trayvon's mother and Mr. Crump, their lawyer. They went to Trayvon's mother's house, and the police, FDLE actually, interviewed her, or I should say Mr. De La Rionda, interviewed her in Miss Fulton, Trayvon's mother's living room, with Miss Fulton sitting next to her.
I've never heard of that.
I've never heard of that. I mean, that's, imagine in the Hernandez case right now, if they went to interview a witness who saw him in an altercation with Lloyd, the victim,
Sure.
and they went and picked up Lloyd's mother and brought her to sit next to the witness to take a statement from.
Right.
It's
Because
absurd.
it unduly influences the
Absolutely.
forthcoming testimony of Gentil.
It completely pollutes it. Yeah, in fact, the witness admitted that she didn't disclose some things because she felt bad for the mother.
You're going to stick around for the hour. Lots more to talk about in the George Zimmerman case. They're in a break right now, but testimony will resume, and so will our coverage. Plus, another twist in the murder case involving former NFL star Aaron Hernandez. Now they're looking at a mortgage